Good morning, everyone. My name is Nina Krieger, and I'm BC's Minister of Public Safety and Solicitor General. It is my absolute pleasure to welcome you all here on the traditional territory of the Musqueam, Squamish, and Tsleil-Waututh people. Thank you all for joining, and I'd like to acknowledge very special guests joining us today. We have Canada's Minister of Public Safety, Gary Anandasangaree, Vancouver Police Chief, Stephen Rye, and Commanding Officer of the BC RCMP, Dwayne McDonald. I'd also like to acknowledge the police leaders behind me who have joined us today, as well as the Member of Parliament from New Westminster, Burnaby, Millardville, Jake Sawatsky. I would now like to call on Minister Anandasangaree to come to the podium.
Thank you very much, Mr. Krieger, for your work and collaboration. I know you've been an incredible partner for us as we've been working on a number of initiatives with British Columbia. And I too want to acknowledge the many police leaders that are here today. And I want to particularly acknowledge the work of our good friend from Vancouver Police, Steve Rowe, who was very much part of the developing of this bill. So I want to just thank you and congratulate you on the work that you've done with your colleagues. Of course, Chief Superintendent Stephen Rye, thank you for your leadership, and Dwayne McDonald, thank you for the work that you do. I'm also joined here by my colleague Jill McKnight, who is the Minister of Veterans Affairs and who represents Delta. So thank you, Jill, and thank you, Jake, for being here. Your presence says a lot about how important this legislation is and why it is so important that we do this now. I want to be clear with you. When it comes to the laws that govern how law enforcement and CSIS gather evidence and information, Canada is woefully behind our most important allies. Our laws have not kept pace with the criminals who break them. Technology have moved forward at a pace that we've never seen before. Our laws are stuck in another century. Criminals know how to exploit this, and they've been doing so for many years. They use many of the same digital tools that are in our pockets or on our desks, but they use them for money laundering, online sexual abuse, extortion, fraud, and human trafficking. And the criminals are organized, often across borders or continents. Their crime is transnational in nature. The tools we have to fight them are inadequate to the task that we have at hand. That is why the legislation our government introduced yesterday is so important for public safety in Canada. When I went across the country, myself and Minister Sean Fraser, as well as Secretary Sahota, the single takeaway from every one of those meetings is the need to have a lawful access framework embedded in Canadian law. Bill C-22 creates a legal framework for a lawful access regime in Canada, something that many here have advocated for decades. Security services and organizations supporting victims have called for it over and over and over again. This new bill has its roots in the former Bill C-2, but it is not the same. This new bill is informed by the views of stakeholders and parliamentarians who voiced serious concerns for the former bill. So when we spoke to many stakeholders after we introduced Bill C-2, what we realized was that we needed to do a bit more work. So that's why I had asked former British Columbia Minister of Indigenous Relations, the Honourable Murray Rankin, to convene a number of tables in order to bridge what could be divides amongst different parties. He convened a number of meetings with law enforcement, with victims groups, with academics, as well as industry leaders. And the result of his work, and I want to thank him for his work, is the legislation we have here today. We listened to what they said, and this new legislation, C-22, balances the needs of law enforcement with privacy and civil rights of Canadians. I want to be clear about what C-22 is not. It is not about surveillance of Canadians going about their daily lives. It is about keeping Canadians safe in the online space. It requires electronic service providers to establish and maintain lawful access capabilities. It ensures that law enforcement can obtain timely, lawfully authorized communications or information when they need it, and only from electronic service providers. It is about creating a consistent and clear legal framework for service providers so they are able to comply with existing legal orders. So this is a package of targeted reforms that tackles the world as it is, not as it was. We're not looking for sneaky ways to surveil Canadians. We respect their privacy. We're doing our part to combat bad actors in both the physical and digital worlds. I know the people of British Columbia want their governments to put their safety first, and I hope you also let your MPs know that swift passage of Bill C-22 is critical in combating modern criminals and the damages they do to our society. Thank you very much, and thank you, Mr. Krieger. Over to you.
Thank you so much, Minister Anandasangaree. The province of British Columbia truly welcomes the federal government's introduction of Bill C-22 Lawful Access Act. This is a very meaningful step forward to ensure that law enforcement has the tools that they need to disrupt crime, to investigate serious threats, and to protect our communities. The BC government, along with policing partners, have long called for meaningful federal action to ensure that the criminal code keeps pace with the constantly evolving ways that criminals are using the digital world to harm our communities. Criminals and sophisticated crime networks are increasingly using digital tools to prey on vulnerable individuals and commit serious offenses like extortions, human trafficking, money laundering, and child sexual exploitation. Far too often, police encounter barriers during investigations where even with a court order, they cannot access critical information about a person of concern. This means that preliminary investigative steps have often stopped before they could even start because the barriers that were involved. With extortion specifically, we know that this crime is a transnational issue, and time is truly of the essence when trying to bring these perpetrators to justice. Providing police the tools to jumpstart their investigations by quickly identifying the individuals responsible for extortion threats can help reduce violence and hold these individuals responsible. We have seen too many examples of BC children being exploited online by anonymous individuals, often from other parts of the world. Providing a pathway to obtain a court order requiring social media companies to provide information allowing police to identify and track down these perpetrators will help keep our kids safe. In short, Bill 22 directly responds to these long-standing concerns by striking the right balance of giving law enforcement the ability to act while maintaining strong privacy protections for Canadians. The bill also crucially brings us in line with other jurisdictions around the world when it comes to investigative tools involving social media companies and online cross-border crime. Our police officers put themselves in harm's way every day to protect British Columbians. This legislation is a watershed moment and will help police get the information they need to advance an investigation in a matter of days as opposed to months. It will remove barriers that hinder investigations and help keep people safe. We are pleased that the law will gradually adapt, allowing it to stay aligned with the ever-changing digital world, so police enforcement can keep up with changing technology. I would like to thank, on behalf of British Columbia, the federal government, Minister Anandasangaree, and other partners for their work on reforming the bill, consulting with a wide variety of stakeholders and addressing privacy concerns and truly making this a priority. Our government remains committed to doing everything we can to make BC a safe and a welcoming province. We will continue to work closely with our federal partners to strengthen public safety, support law enforcement, and ensure laws are responsive to the ever-changing realities of today's world. Together, I know that we can build safer communities and directly confront those who threaten public safety in Canada. Thank you again, and I'd now like to invite Vancouver Police Chief Constable Steve Rye to offer remarks.
Good morning, and thank you, Minister. So the growth of modern smartphones and telecommunications networks has brought rapid and dramatic change to the world around us. While many of these changes have made our lives easier, they have also created new opportunities for criminals who use telecommunications to plan, execute, and finance crimes that threaten our public safety. Unfortunately, existing laws have not kept pace with these technological changes, and as a result, the work of identifying offenders, solving crimes, and keeping our communities safe has become much more difficult. While Bill C-22 is just one step, we believe it is a step in the right direction, one that balances the operational needs of police with the privacy rights of our citizens. It is a pragmatic and sensible approach that will help law enforcement agencies. It will streamline investigations, keep pace with a rapidly changing digital world, solve crimes more quickly, and secure critical evidence that enhances public safety. Here is one example of why this matters. The Vancouver Police Department's Internet Child Exploitation Unit receives more than 600 files each year to investigate. In 90% of these cases, investigations begin with limited information. This means officers must obtain judicial authorizations and serve production orders on telecommunications companies before the investigation can even move forward. The tools proposed in Bill C-22 would make it easier for police officers to identify which telecommunications service provider an offender may be using to commit these crimes. This allows investigators to move forward more quickly, to serve production orders, and secure critical evidence. The legislation would also require service providers to respond with requested information within a much shorter time frame once a production order has been served. By allowing police to efficiently identify which service providers to serve production orders on, and by requiring faster responses from these providers, Bill C-22 would improve our ability to focus investigations and resources, identify suspects, and locate victims who require support and protection. The lawful access tools proposed by the federal government would have similar impact on other serious crimes, including kidnappings, fraud, human trafficking, and violent robberies. While this proposed legislation represents a significant step forward, it also ensures that any private information gathered during a criminal investigation is obtained lawfully and in full compliance with the Charter of Rights and Freedoms. I believe this legislation strikes an important balance by assisting police, law enforcement, while also protecting the privacy rights of our citizens. In closing, I would like to thank the Federal Minister Anandasangaree, Solicitor General Krieger, Deputy Commissioner Dwayne McDonald, and all of the police leaders here today. Thank you.
Thank you very much, Chief Rye. And now I'd like to call on Commanding Officer Dwayne McDonald to say a few words.
Good morning, everyone, ministers and colleagues. To effectively investigate crime in today's digital world, the RCMP needs modern lawful access legislation. Simply put, the way people communicate has changed, but the tools available to police have not kept up. Across the country, investigators are facing real challenges, including getting timely access to information that they are already legally authorized to access, especially in the early stages of an investigation when time matters most. That creates delays and inefficiencies for everyone involved. We, the police, would benefit from standardized processes. Let me provide you with an example to help everyone understand the importance of timely access to key information during an investigation. During a recent internet child exploitation investigation in 2025, police served a production order on a service provider. While judicial authorizations in support of child exploitation cases are typically actioned quickly, the investigator in this case was advised by the service provider 27 days after being served that the turnaround time for further action was going to be between 25 to 30 days for production orders, and that could not be completed any sooner. During this time, the investigation was unable to proceed. It stalled, which leaves our victims further at risk. As you can see, delays give suspects time to continue committing crimes and putting victims at risk. And I know this sounds similar to the statements of my colleagues, but the reason it does, and I actually joked with Chief Rye beforehand that we should just switch speeches because they say the same thing, as this is a universal problem across law enforcement, and it has been for decades, and it needs to be addressed. The reality is that crime has become more complex and it transcends borders. The current online environment makes it easier for threat operators to operate in Canada and around the world. Law enforcement needs to be better equipped to work with domestic and international partners to prevent and investigate digital crime, just as we do with physical crimes. Right now, Canada does not have a modern legislative or regulatory framework that compels service providers to assist law enforcement or govern lawful access. In fact, we're relying on licensing conditions under the Radio Communications Act that have not been updated since they were introduced in 1995. Bill C-22 would modernize the lawful access authorities. Consider again the example of the child exploitation case. Had the authorities included in Bill C-22 been in place, there would be new options available to investigators. They could issue a confirmation of service demand and find out quickly if the service provider had records. If a production order is needed, there would be clarity that would result in shorter response times. These measures would mean less victims are at risk. We believe that the proposed legislation strikes a balance that respects the privacy and the safety interests of Canadians. We appreciate the government's continued support for lawful access legislation, and we hope that it will receive the support it needs to succeed. So thank you very much.
Thank you very much. This now concludes the morning's event, and we will now take questions from the media.
Thank you. If you could just state your name and address and include your question directly to with one question and one follow-up.
Good morning, Minister, and good morning, people here. Thank you for this information. Shall we go?
My apologies. We actually do have one additional speaker, Deputy Chief Constable Andrew Chan, who is also president of the BC Association of Chiefs of Police.
Thank you very much, Minister Krieger, and good morning. I'm pleased to be here today alongside the federal and provincial public safety ministries and Chief Constable Rye and Deputy Commissioner McDonald. As president of the BC Association of Chiefs of Police, I'm honored to speak on behalf of police leaders across British Columbia. The landscape of policing has fundamentally changed. Serious crime today, including organized crime, child exploitation, extortion, fraud, and threats to national security, now often occurs online, across borders, and at a speed that did not exist when many of our investigative laws were written. Bill C-22 is about catching up to that reality. This legislation is designed to help police identify offenders in the digital space, quickly, lawfully, and with clear rules. It allows investigators to determine which service provider may hold information relevant to an investigation, and then requires police to go to court to obtain identifying information. From a policing perspective, this matters because delays in digital investigations have real consequences. Lost time can mean lost evidence, unidentified offenders, and victims left at continued risk. When a judge authorizes access, police must be able to obtain that information in a timely and consistent way. Bill C-22 also brings clarity and consistency. Today, lawful access can vary depending on the service provider, the technology involved, or where the investigation occurs in Canada. That inconsistency creates public safety risks. Clear national standards support fairness, accountability, and reliability across the country. I want to be very clear, and you heard it from my colleagues, police leaders in British Columbia take privacy and charter rights seriously, and public trust matters. The BC Association of Chiefs of Police supports Bill C-22 because it strengthens oversight and safeguards while providing investigators with modern, targeted tools to protect the public. Public safety and privacy are not in conflict. When done properly, they can go hand in hand. On behalf of the BCACP, I would like to thank the federal and provincial public safety ministries and the Canadian Association of Chiefs of Police for the collaboration that brought this bill forward. And we look forward to working together on this. Thank you.
Thank you so much. It's incredibly meaningful to have the perspective of the BC Association of Chiefs of Police. And now we will indeed open it for questions.
Thank you. Good morning. My name is Parmeet Kamra. I'm from Omni News, and my question to you, Minister, is many crimes like extortion are run by organized crime groups operating across the borders. How will this bill improve cooperation with international partners to disrupt these crimes?
Well, thank you for that. There are certainly provisions in the bill that will enable Canadian law enforcement to access information across borders. So we do have a mutual assistance agreement with a number of countries. For example, many of the social platforms may be situated south of the border, and the mechanism that's available with Bill C-22 enables law enforcement to seek, first of all, a confirmation of service, and then from there, additional production orders, for example, subscriber information, and then if additional information is required, they will be able to seek that all through judicial means. So safeguards are in place, but more importantly, it does enable our law enforcement agencies to get information that are outside of Canadian borders.
My follow-up to is, Minister Nina Krieger, to you is, will BC need to invest more in digital forensic units or cybercrime teams if these federal bill came into force?
So we are confident that our existing teams, and certainly BC is very proud of the work of the Combined Forces Special Enforcement Unit, Canada's largest integrated unit targeting organized crime, and the other specialized units that we have dedicated to extortion, the BC Extortion Task Force, human trafficking, hate, and so on. And so we really feel that this is a very significant step forward and something that BC law enforcement partners have long been advocating for, to enable our police to track criminals and hold people accountable for the challenging crimes of our time that include extortion, cybercrime, and so on.
If I may just add, in fact, this would, in my opinion, and the law enforcement's here, it would in fact enable law enforcement to do more work, because it takes away from the onerous task of preparing production orders on very simple questions of, is this individual a client of this company, for example, telcos. So it will, in fact, take a lot of time out of the arduous task that's already there. And I'm hoping that that could be used towards other investigations and being able to close files a lot faster.
Hi there, Penny Daffos from CTV News. This is for either one of the ministers to answer, or both of you can if you'd like. This essentially sounds like a modernization of wiretap laws, so I'd like you to explain how Canadians can be confident that if they've done nothing wrong, they're not going to be caught up in this, because it sounds like it's quite sweeping authority.
It's actually not. So let me just frame this. There's three major components of this bill that will enable law enforcement to obtain information. The first piece is a very simple question of yes or no that will be restricted just to telcos. So, for example, if you have a cell phone number that is attached to company A, this bill will enable law enforcement to contact that A company and say, is this individual or is this phone number attached to your service? That is done without warrant, and that is a very simple task. So if you go back 30 years, and I, as a lawyer, I've had to do this. If I had somebody's phone number, I would go into the library and look at a book called Bowers, still in the library right now, and you would in fact be able to find not just the individual's phone address, but also their names and a lot more revealing details. This doesn't even go as far as that. All this does is enable law enforcement to see if this phone number is attached to this company. That's the first piece. The second piece is when judicial oversight is in place. So we will be able to obtain subscriber information, so basic information about the individual whose phone number has been identified with that company. And the information would be the name, the address, potentially an email address. And it is limited to that, and that is based on a reasonable grounds to suspect legal standard with judicial authorization. So it's not done arbitrarily, it's done with a judge overseeing the approval of that order. The third element, which is essentially what's there right now, will enable law enforcement to go into prepare an authorization based on a reasonable grounds to believe basis, and be able to obtain additional information. For example, if there's text messages on extortion that was sent on Sunday at 3 in the afternoon, they'll be able to get information such as that in order for them to conclude the investigation. It in no way enables additional powers to law enforcement. What it does is allow law enforcement to have a tool that minimizes the initial process of identifying where this phone number or email address or account is attached to, just in the digital telecommunication space.
So then my follow-up is, whichever police leaders want to address this, how meaningful is this in practice to actually speed up investigations? Like, are we just talking a few days, or is this, just like one aspect of like certain files? And, are you looking at applying this potentially, aside from like the most serious like child exploitation, like are we also talking about romance scams, extortions, the things that we get almost weekly press releases from you that are digital issues that you're dealing with?
Yeah, you and Mike, you want to jump in?
I would say one of the biggest benefits of this legislation is the speed in which police can access the information that we already have the ability to access. If you take any investigation in the criminal code, whether it's a low-level, say like an auto offense, or all the way home invasions, carjackings, homicide, national security, all of that, phone numbers or internet addresses are often key, and a key starting point and a building block for an investigation. Having the ability to simply say and contact a telco provider and say, does this number exist in your records? Is this a customer of yours? With a yes or no response, enables police to focus their applications, their production orders that require judicial authorization specifically to that company, rather than writing multiple search warrants in the hope that sooner or later we will identify that company. So it speeds up the process there. The production order itself, that process is expedited under judicial authorization. So it enables us to focus the investigation quickly and obtain information that's necessary to advance. I'll turn it over to Mike as well.
Yeah, hello, I'm Superintendent Mike Rowe from the Investigation Division of the Vancouver Police. And just to add on to Deputy Commissioner McDonald's statements there, the other additional piece in this is not only will it allow us to more quickly identify which service providers to obtain warrants for, to get that information, it will also strengthen our ability to obtain production orders. So we'll be able to get a better production order, provide more accurate information to the judiciary when seeking that production order. Additionally, the decreased time frame from the current 30 days down to 10 days for telecommunications companies or electronic service providers to respond back to those production orders is going to be a significant time savings for investigators, because each of those production orders are typically cascading. One production order will lead to another production order throughout an investigation. So when officers are forced to wait and investigations are stalled waiting for results, that can lead to weeks, if not months, of time savings on a wide variety of investigations. So this bill, if passed, will have a significant impact on the pace of our investigations and our ability to investigate a wide variety of crimes. Because as was said here before, in virtually every case that we deal with now, basic cell phone information, IP addresses, electronic service provider information is one of the key building blocks of those investigations.